the slide that you see shows some images from the history of disability rights. And I hope they serve as a reminder that all the progress we have achieved, all the opportunities that we have available to us now is because of all the long, hard struggles and challenging work of the ones who came before us. We stand on the shoulders of giants. In the upper left-hand corner is a photo of Judy Human, who is speaking. Judy, we recently lost just a little over 4 months ago. She was such a friend and mentor to so many of us. You may have heard that she is called the mother of the disability rights movement. But Judy says, some people say that what I did changed the world, but really, I simply refused to accept what I was told about who I could be, and I was willing to make a fuss about it. So inspired by the civil rights movement that Black folks engaged in the 60s, the disability rights movement emerged, and people just decided to stop accepting the tyranny of low expectations and to fight to be included, and for people to recognize that disability is simply part of the human experience. So Judy really cut her teeth in the fight for the Section 504 regulations. As many of you know, they overtook a federal building in San Francisco and held it for almost a month. And the regulations were signed, and people with disabilities were shown their strength. And we've been fighting ever since. Below the picture of Judy is a picture of the Capitol crawl. And this was one of the many events that led up to the passage of the Americans with Disabilities Act. And you can see the signing by President H.W. Bush, with Justin Dart looking over his shoulder in the top right image. And imagine getting such a sweeping, comprehensive civil rights act passed today. It is mind-boggling. And one of the reasons that we have the ADA is people with disabilities chose not to play divide and conquer. They tried to peel off groups, separate them from each other, make promises separately to each group, and everybody stood shoulder to shoulder. They stood strong. They refused to play that game. And that's why we have such a strong cross-disability Civil Rights Act that we can rely on still to this day. So there's so many disabled folks right now who don't know any other world besides a world where there's an Americans with Disabilities Act. So there was a major Supreme Court case. You can see the named plaintiffs in the center picture. That's Elaine Wilson and Lois Curtis. And they wanted to live in the community. They did not want to be relegated to life in a facility. And that's what we commonly refer to as the Olmstead decision today. The final image in the lower right is Ruth Bader Ginsburg, who authored that landmark decision. As you have heard, Olmstead is a Supreme Court decision that interprets the meaning of Title II of the Americans with Disabilities Act. And in passing that act, Congress made some findings on the record. One of the findings that our Congress made was that historically, society has tended to isolate and segregate individuals with disabilities, and despite some improvements, such forms of discrimination against individuals with disabilities continue to be a serious and pervasive social problem. So I want to talk a little bit about the United States Department of Justice's definition of an Olmstead Plan. And I'll read from the slide. An Olmstead Plan is a public entity's plan for implementing its obligation to provide individuals with disabilities opportunities to live, work, and be served in integrated settings. A comprehensive, effectively working plan must do more than provide vague assurances of future integrated options or describe the entity's general history of increased funding for community services and decreased institutional populations. Instead, it must reflect an analysis of the extent to which the public entity is providing services in the most integrated setting, and it must contain concrete and reliable commitments to expand integrated opportunities. Concrete and reliable. Just to expand a little bit on what DOJ says about Olmstead plans, it says in order for an Olmstead plan to serve as a reasonable defense against legal action, it must include concrete and reliable commitments to expand integrated opportunities, and there must be funding to support the plan. DOJ went on to say that integrated settings are located in the mainstream society, offer access to community activities and opportunities at times, frequencies, and with persons of an individual's choosing, afford individuals choice in their daily life activities, and provide individuals with disabilities the opportunity to interact with non-disabled persons to the fullest extent possible. So these settings that we're talking about are called HCBS. Home and community-based services. Olmstead compliance requires access to HCBS. Here in North Carolina, most of these HCBS services for people with intellectual and developmental disabilities depend on having an innovations waiver slot. Unfortunately, the waiting list for an innovations waiver slot is over 17,000 persons. That is more than the number who are being served with an innovation slot. More people are waiting than are being served. And those who are lucky enough to have that innovations waiver slot are struggling to find providers. I want to talk about North Carolina's lack of a true Olmstead plan. Having a real Olmstead plan means that it works to provide adequate HCBS. We don't have that. The United States Department of Justice requires that an Olmstead plan must have specific and reasonable timeframes and measurable goals for which the public entity may be held accountable, and there must be funding to support the plan. In the Samantha R. case, I think some of you are familiar with the Samantha R. case. It's Disability Rights North Carolina won that case on summary judgment in February 2020. Also known as the last month we had freedom to move about the country before the pandemic. February 2020, we won that case on summary judgment. And now we're trying to work toward a remedy, a meaningful remedy in that case. So the judge in the Samantha R. case reviewed the state's 2021-2023 Olmstead Plan and determined that DHHS and the state have not provided an actionable plan with specific and measurable goals for compliance. So where do we go from here? We have to do this. Remember that first slide with Judy Heumann and Justin Dart and a Capital Crawl and Elaine Wilson and Lois Curtis. Remember I talked about how people refused to play the divide and conquer game. People stood shoulder to shoulder. They stood strong and they fought for what they needed. They fought for their vision. They fought for what they knew they had a right to expect. So this community, the intellectual and developmental disability community and people with all disabilities in North Carolina have to be engaged and drive the change that we need here. We must demand an aggressive approach to eliminating the waiting list for services. We must demand that the new 1915I services are robust and can meet the unmet needs of those waiting for an innovations waiver slot. We must demand that the LME MCOs fulfill their duty to ensure that services are available for those who do have an innovations waiver slot. And we need to demand that the LME MCOs engage in in-reach and diversion to ensure that those who want to live in the community can do so that everybody has a choice.